Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So, this is a Diddy update. So, as we spoke in the last video, we pretty much was talking about how we were waiting on a filing from they had a deadline of today to file a joint letter with any concerns or issues that they wanted to address at tomorrow's hearing on the motion to dismiss count three. And they have since then submitted that filing. And y'all, I know y'all already seen it on TMZ. That's why I had to rush. I flew Spirit to my court filing system to pull this. But they are saying, the defense counsel is saying, that the video that CNN released with Diddy dragging Cassie and, putting hands on her and everything at the hotel, they're saying that the video was destroyed and CNN had the only copy. I'm speechless because what? I thought, let me get this right. So Diddy paid the hotel to get the copy. The defense counsel, not the defense, I'm sorry, the prosecution, the government, not even the government. Let me take that back. Law enforcement obtained that video from the home of Diddy. Are you telling me that they sent CNN the only copy that they had? Please make this make sense, because it's not making sense at all. But without further ado, let's hop on into this new joint filing from the government and the defense counsel. This is what we have been waiting for, to see what issues are going to be addressed at tomorrow's hearing. So this was addressed to Judge Subramanian. They submit their joint letter in response to the court's order that was dated yesterday, directing the parties to outline the issues the parties believe should be addressed at the pretrial conference scheduled to proceed on tomorrow at 2 p.m., in addition to defendant's arraignment on the superseding indictment. So there is a lot that is going down tomorrow. All right, so Diary. Vior Daddy. So we are going to tap into the government's position as well. So normally how it goes is the government will provide their position, and then the defense counsel will actually present their position. Now, Vior Daddy, I hope I'm saying it right. It's French. It is to speak the truth. All right. So the attorneys and the judges question potential jurors to ensure partiality and determine their suitability for jury service. So this section is going to be in regards to the jury, as well as any type of witnesses and their competency during this trial. So let's get into this. So the government respectfully requests that the court commence VR Dari prior to the scheduled trial date of May 5th, 2025, with the intent to present preliminary instructions and opening statements to the jury on May 5th, 2025. The schedule will decrease the risk of scheduling issues during trial and does not prejudice the defendant in any way. First, if the court does not commence VR Diary prior to May 5th, 2025, the trial will likely last beyond the July 4th holiday, creating unnecessary additional challenges in seating a jury. This is based on an estimate agreed upon the parties that the VR Dari may last up to 2 weeks. The government's case in chief may last up to approximately 6 weeks, and the defense case may last up to approximately 2 weeks. Second, conducting Vior Dari prior to May 5th, 2025 will ensure both witness availability and efficient scheduling. Indeed, many of the government witnesses must travel from out of state to testify, and a date certain to begin testimony will enable the government to more efficiently schedule witness travel and avoid unnecessary trial delays. Further, this schedule does not prejudice the defendant. In fact, the defense initially requested a trial date in April or May of 2025. Accordingly, the government respectfully requests that the court order Vior Dari to begin on Monday, April 21st, 2025, with preliminary instructions and opening statements to be delivered on May 5th, 2025. Now, the defense position on this. The defense proposes the jury selection begin on May 5th and May 6th with two written questionnaire days. We propose that the jury clerk summon 300 jurors on May 5th, 2025 to complete written questionnaires administered and supervised by the jury clerk on site at the courthouse. We propose that the jury clerk summons an additional 300 jurors on May 6th to similarly complete the written questionnaires. The parties will then collect and review the completed questionnaires, I can't even talk, and lodge for cause challenges between May 6th and May 8th, 2025, with agreed on challenges reported to the court on May 9th, 2025. On May 12th, 2025, we propose proceeding with jury selection from the pool of remaining jurors to be completed that day, with the preliminary instructions and opening statements scheduled to follow or start on May 13th, 2025. Commencing Vior Dari on an earlier schedule would substantially prejudice the defense, as we have been planning to proceed with trial no earlier than May 5th, 2025. Among other things, we have a tremendous amount of discovery to review and prepare in advance of trial. As the court is aware, we request a sequestered jury selection process in which the jurors are questioned individually outside the presence of the other jurors. This is consistent with the practice in other high profile cases of this nature. And they stated United States versus Renier and United States versus Maxwell. Maxwell? I wonder if they're talking about Jeffrey Epstein's Maxwell. All right, so let's talk about the jury questionnaire. Government. The government respectfully requests that the court refrain from using a jury questionnaire, or in the alternative, using a juror questionnaire limited only to logistical issues. Rather, any conflicts would prevent a juror from being seated for an 8-week trial, rather than substantive questions. The court has set a deadline of April 11th for the parties to submit proposed jury questionnaires forms. Due to the publicity surrounding the case, however, a jury questionnaire containing substantive questions would likely prolong jury selection and lead to an undue waste of judicial resources that is neither in the interest of the public nor of the prospective jurors. If a jury questionnaire was administered in this case, the government understands that the process would entail one, summoning prospective jurors to the courthouse to read through and complete the jury questionnaire. Two, a review of the jury questionnaires by the court, the defendant and his counsel, and the government to determine which jurors, if any, should be removed from the veneer for the cause. And three, oral VRDID, which would likely involve follow up questions to clarify the answers provided on the questionnaire. This three-step process will likely take at least several days, if not longer. An oral via diary, I need to make sure I'm saying that right, diary, would eliminate the first two steps while still appropriately disposing of for cost challenges. Jury selection would begin with the oral questioning of prospective jurors, and the parties would propose juror strikes the same day. In-person questioning would also allow the court and the parties to directly assess the jurors and their responses, and to ask follow-up questions on the spot. Such a process would be more expeditious and less cumbersome, and will lead to the same outcome: the selection of a fair and impartial jury. In alternative, a questionnaire limited to scheduling conflicts is most appropriate in this case. Da, 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 da. Okay, so they started citing other cases. All right, so here's the defense position on this. The defense requests that the use of written questionnaire would, which we would understood the court had already ordered based on its January 8th, 2025 order setting a deadline for submitting proposed questions. We will propose a questionnaire on the date set by the court. I do remember seeing that. District courts routinely employ questionnaires to facilitate validity in a number of circumstances, and the use of such a procedure as a preliminary screening tool falls well within the district court's broad discretion. Y'all, it's crazy because I used to live in Canada when I was little as a teenager, and we was required to um, speak not Spanish, Lord, French. So I know a little bit of French. I know how to do my ABCs and my numbers and like um what is it called? Like when you greet, you're saying your name, you're greeting, you're asking them how their day is. I know how to say that. Yeah. Okay, so it's called is oh this I don't like the way that they say this. Hold up. Let me see. Let's see what Google says. Speechmodification.com presents. Girl, just say it. Voir dire. Oh, it's voir dire. Voir dire. Voir dire. All right. So voir dire. Voir dire. Got it. So voir dire. Everybody got it? All right, cool. Um Let's see. The pre-trial publicity in this case has been nothing short of extraordinary. It has been incredibly one-sided in favor of the government's view of the evidence, and often worse in light of many false and unfounded claims being filed by civil plaintiffs and against Mr. Cohn. Potential juror bias must be rigorously ferreted out in the jury selection process so the parties can proceed with the impartial jury and receive a fair trial. Indeed, the Second Circuit has not hesitant to reverse district courts when jurors' bias is not adequately addressed during the jury selection process. This too is a widely used practice in other high-profile cases. Again, they cited Rainier and Maxwell. Contrary to the government's view, a wisely administered questionnaire will make jury selection quicker and smoother. Finally, issues of potential juror bias are of paramount concern in this case due to repeated government leaks and other prejudicial issues that we already brought to the court's attention. Boy, 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 boy. Now we're talking about defense discovery. To date, the government has made 25 discovery productions. God, dog. To the defense. However, the government has yet to receive any discovery from the defense pursuant to its obligations under Rule 16b1. On October 7, 2024, at the time of the government's first discovery production in this matter, the government requested in writing reciprocal disclosures from the defendant pursuant to Rule 16b. Since then, the government has repeatedly renewed its request in connection with subsequent discovery productions. However, as of March 13, 2025, at 12 p.m., the government has yet to receive any discovery from the defense pursuant to its obligations under Rule 16. Oh, that's crazy. It's March. We have less than 2 months until trial, and the defense have not given anything to the government, but have been hounding the government to give. Okay. The government is aware that the defense obtained Rule 17C subpoenas, which were so ordered by the court, and has requested the production of those records from the defense. However, the defense has informed the government that it does not intend to make any disclosures until it determined that such material is certain to be part of its case in chief at trial. A determination that is not yet made with respect to any of the records it has received. The court should order the defense to promptly produce any Rule 16b materials in its possession, including Rule 17c subpoena returns. Pursuant to Rule 16b, when a defendant requests disclosure under Rule 16a1e and the government complies, the defendant must make reciprocal disclosures. That's true. Consequently, courts in the district and elsewhere routinely require defendants to produce Rule 16b materials before defendants have made decisions about the scope of any defense case, let alone whether a particular piece of evidence will be offered at trial. Hold on, let me see something. Da, 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 da. What is this? Rule 16b. Okay, they're talking about scheduling. I don't think this is it. Okay. Oh, I'm looking up federal rules of civil procedure instead of the criminal. I always do that. All right, this makes sense. All right, so in a federal criminal procedure, Rule 16b addresses defendants' reciprocal obligation to disclose information to the government, specifically regarding reports of examinations and tests upon the government's request after the defendant has requested and received similar information from the government. All right. Um, let's see. Consequently, courts in this district and elsewhere routinely require defendants to produce Rule 16b material before defendants have made decisions about the scope of any defense case, let alone whether a particular piece of evidence will be offered at trial. With respect to Rule 17c1 material, the rule makes no reference to ex parte subpoena returns and instead states the material will be returned directly to the court, which may permit the parties and their attorneys to inspect all or part of them. Because the court's authority should not be invoked to permit trial by ambush, it is the majority view of the courts that the structure of Rule 17 require the court to allow both parties to view the documents returned under the subpoena. Let's see. In other words, assuming that Rule 17C subpoenas were properly issued, the responsive materials are necessarily subject to disclosure under Rule 16. That's sad that they have not. I don't know. This is crazy. What is Mark Agnophilia is doing? In order, requiring the defendant to promptly produce Rule 16 material, including responses to the Rule 17C subpoenas, is also necessary for fairness. The defendant appears to be taking the position that he need not produce any materials until an unidentified future date, if ever. The position does not comport with the defendant's reciprocal discovery obligations and is not in the interest of justice. Exactly. The federal rules of criminal procedure outlines what both parties have to do, and you have to abide by that. Accordingly, the government respectfully requested the court order the defense to promptly produce any Rule 16 materials in its possession, including Rule 17C subpoena returns in accordance with the federal rules of civil procedure. Oh, I'm sorry, criminal procedure, and to produce reciprocal discovery on a continuing basis thereafter. Such productions will serve to prevent the defendant from reaping unfair tactical advantage by violating the rules and avoid any unnecessary trial delays. All right, defense position. They say the defense is aware of its obligations under Rule 16, fully intends to comply with them, and never suggested otherwise. In fact, during a recent meet and confer, which was yesterday, the defense explicitly informed the prosecutors that we would be complying without our Rule 16 obligations. To the extent the court is inclined to impose a deadline for additional disclosure, we would suggest a deadline closer to trial and after the government has produced its exhibit list, as been done in other cases in the district. I'm about to say, huh? All right, in United States versus what is this Schwartzman? Let's see, it says ordering defense Rule 16 productions due 4 days after the government exhibit and witness list and 5 days before defense exhibit. Huh, that's interesting. That is interesting. Then they cited another case, United States versus Bankman and Fry, where it was ordered defense Rule 16 productions due 10 days after the government's exhibit and witness list. Such a deadline is more appropriate to ensure that we have time to determine, in response to the government's case, what material we plan to use in our case in chief. Because the government has the burden of proof, the defense has not made any decisions about what evidence it might introduce should it put on a case in chief, and thus should not be compelled to disclose material to be admitted as part of the defendant's case in chief at this stage. Indeed, until the defense is aware of the government's witness and proposed exhibits, we are not in a position to know what, if any, materials will be used as part of our case in chief. That is why the courts often set deadlines for Defense Rule 16 productions at a date after the government discloses its witness and exhibit list. As the above examples, in addition, if any defense obtains any evidence it plans to introduce in its case in brief after such deadline, which evidence would be produced promptly. Boy, I'm on the fence about this one because I mean, it has been done in other cases. But at the same time, the defense counsel wanted an earlier trial date. So I'm wondering if the cases that they cited, the Schwartzman and the Bankman fraud, are these similar cases in which trial was set at an earlier date, earlier than usual? And that's why the court allowed them to produce those disclosures, either 4 days or 5 days after the government has produced their witness and exhibit list. The things that make you go, hmm. All right. So, moreover, to the extent the government is seeking preclusion of any evidence disclosed after any such deadline, we note that the government itself has repeatedly violated the December 31st, 2024 deadline for producing all of its discovery. See 10-10-24-minute entry. It has produced an enormous volume of discovery, approximately 46.36 gigabytes after the deadline, and continues to do so despite the trial preparation challenges the defense team already faces due to the unprecedented amount of discovery the government has already produced by the deadline. Hey, look, y'all asked for an early trial date and they're producing everything that y'all want them to produce. Like I like delay the trial then. If y'all feel that y'all are getting an overwhelmingly amount of discovery, push the trial date. It's like you can't have your cake and eat it too. You want an earlier trial, but you want to make sure that you and your client has enough time to review the enormous amount of discovery that y'all are getting and requesting from. Make this make sense, please. Anywho's, I'm gonna reread that again. It has produced an enormous volume of discovery after that deadline and continues to do so, despite the trial preparation challenges the defense team already faced due to the unprecedented amount of discovery the government has already produced by the deadline. We do not know whether there is any excuse for that or when the government obtained the materials it has produced, I'm sorry, since that deadline, but obviously any remedies for violations of disclosure deadlines must be applied in an even-handed manner to both parties. Finally, the government's argument regarding ex parte returns of Rule 17C materials, the subpoenas, is inconsistent with the practice of courts in the district and unsurprisingly unsupported by any controlling authority. Nevertheless, the defense will produce the material it obtained through Rule 17 subpoena tomorrow, even though we do not presently intend to introduce this material as part of the defense case in chief. Specifically, this production will include a subpoena response by CNN with copies of surveillance footage from the March 16th Intercontinental Hotel incident. The defense has confirmed through a forensic video analysis of the CNN footage that the government provided to this court and of the footage provided by CNN in response to the defense subpoena that all CNN video footage was substantially altered in significant respects. This includes covering the timestamp and then changing the video sequence. It also includes speeding up the video to make it falsely appear that the actions in the video are taking place faster than they are. As a result, the CNN videos do not fairly and adequately depict the events in question. So, what they're saying is CNN probably played the video, and in that video, if a certain action, like her standing by the video, what if I mean standing by the elevator, and then her going down the hall or being dragged, that what they're saying is it's out of sequence. So they played something that was actually, last first, and something first last or in the middle, and then they sped up the video. I don't even know how long the actual video is. Okay, I get that. But he still did what he did in the video. Finally, the defense has confirmed that CNN purchased The only known copy of the hotel surveillance footage uploaded the footage into a free editing software, altered the video, and then destroyed the original footage, even though it knew about and repeatedly reported about the federal investigation. I really don't see why. Okay, so they purchased the video, the only copy. Like, I don't see anybody saying, okay, I'm going to give you the only copy that we have, knowing that that is evidence. This would be the subject of the upcoming motion in limine regarding the CNN derived footage. We will be disclosing the subpoenaed materials to the government, so it will be prepared to respond to the defense motion on the subject. Motions, the party will be ready to answer any inquiries from the court about the pending motions. As far as the pretrial conference, the final pretrial conference, to ensure that they are getting ready. So, pursuant to the court's January 8th order, the parties' motions in limine will be fully briefed by April 11th, 2025. The government therefore respectfully requests that the court schedule a final pretrial conference for the week of April 14th. Such a schedule will permit parties to incorporate the court's ruling sufficiently in advance of trial. Defense position, they are stating that the defense requests that the final pretrial conference be scheduled for the week of April 28th. Such a date would fall after the party's final pretrial filing deadline of April 25th and will permit a more productive final pretrial conference. Um, there you have it. The biggest thing that I think we're going to take away from this is the CNN. So the defense counsel subpoenaed the video from CNN, and CNN stated that they allegedly destroyed the only copy there was. The defense counsel hired a forensic expert to view that video and found several things, like the timestamp being covered up. The events that took place in the video were out of sequence. The video was sped up. I I don't see the government. Not I'm not I'm gonna take the government out because it's not the government, it's not the prosecution. I don't see law enforcement handing over the only copy of that hotel video footage to CNN. I just don't see it at all. Y'all let me know what y'all thoughts in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.